Hi, on April 17th in the Federal Register was published a notice called Rescinding the Definition of Harm under the Endangered Species Act. I wanted to spend a minute talking about the ramifications of this proposed rule change for the Fish and Wildlife Service and NOAA, and urge you to submit a comment on the Federal Register site. Thus far, there have been just under 15,000 comments on this. Just a quick perusal of these. By and large, they seem to be in opposition of this proposed rule. In the Endangered Species Act, Congress says that we are not to harass, harm, hunt, pursue, shoot, kill, maybe a couple other words, endangered species, or attempt to do so. And that also within the Endangered Species Act, there is an incidental take permit process. In other words, if you're doing something that will incidentally cause harm to a species, that you need a permit for that. So these two different bits of the Endangered Species Act were used in 1995 by the U.S. Department of Interior in a case called Babbitt versus Sweet Home, which went all the way to the Supreme Court. And it was about spotted owls in the Pacific Northwest. The gist of this case was that Babbitt and the Department of Interior were arguing that harm should include damaging habitat for endangered species. If this proposed rule was in effect, it would preclude the Fish and Wildlife Service from negotiating with private landowners when they proposed development or land use change that damaged the habitat of federally listed species. As long as it didn't kill the species outright, it would be okay. To use the example from Babbitt versus Sweet Home, this would be in effect saying that it would be okay to cut down a forest of trees that spotted owls used as nesting habitat as long as you didn't kill any spotted owls in the process of doing that. And Babbitt versus Sweet Home established by the U.S. Supreme Court that harm, in fact, included the habitat, and thus it was made illegal to harm the spotted owl by destroying its habitat. I'm a conservation scientist who's never taken a law class, so take my analysis of the legal aspect of this with a grain of salt. But that said, I went to look at Babbitt versus Sweet Home. In Babbitt versus Sweet Home, the judges, 6-3 majority, said that there are three reasons why they would define harm as destroying habitat. First, it's the ordinary meaning of harm. That this ordinary meaning naturally encompasses habitat modification that results in actual injury or death to members of an endangered or threatened species. Now, this would be like thinking, well, if I burned down a house but did not kill the people inside the house and then said, well, no harm because they didn't get killed, I'd be laughed out of the room. You know, that's a ridiculous argument that there's clearly harm. And the second is the ESA's broad purpose of providing comprehensive protection for endangered and threatened species. When you have a law that says harass, harm, shoot, pursue, hunt, kill, it's clear that the intent is very broad. The third argument these justices made was related to the incidental take issue, that said no one could seriously request incidental take if they knew they were killing organisms. And so incidental would refer to things like doing something that incidentally harmed the species, like its habitat. And so this seemed like a reasonable definition and not an interpretation of the intent of Congress, but actually a reading of the intent of Congress. So Justice Anthony Scalia dissented from this opinion. Scalia spoke about the Chevron deference to agencies in decision making, and this becomes important because the Fish and Wildlife Service and NOAA have used the Loper-Bright as part of their support. Now, that Loper-Bright decision walks back a long-standing notion that the courts ought to give deference to the technical expertise of agencies in rulemaking. So the interesting thing in this ruling is that it's forward-looking, not backward-looking. And they say by overruling Chevron, the court does not call into question prior cases that relied on the Chevron framework. They're saying that the holdings from those cases are still subject to long-standing law. And this means that the courts are saying in this document right here that Babbitt versus Sweet Home remains a valid decision. So this is a case of agencies deciding to create a rule that runs directly counter to a Supreme Court decision. So if I were a betting person I'm going to say that this proposal gets adopted despite overwhelming opposition. This is going to chew up a huge amount of time and energy by the vastly reduced workforce of Fish and Wildlife Service and waste agency money from things that they could be doing that are actually for endangered species. The proposed rule will be then challenged in court. More time and resources. The Supreme Court will point to the Loper-Bright thing and say you need case law to do this. The administration will have to find a plaintiff on a Section 10 or a Section 7 consultation process where they decline a permit, which is something they don't do very often, and make sure this gets up to the Supreme Court. This could take years. And so I'm urging you to submit a comment to the Federal Register, but we should all be aware that this is a beginning of a long process and that we need to remain vigilant and work in every way possible to make sure that this doesn't become part of policy, because it'll really hamstring the agencies in their capacity to protect endangered species on public and private lands. Thanks. Now I have to pause for this airplane again.